Okay, next we're going to talk about a very common type of evidence, which is testimony. Testimonial evidence, people saying stuff, people testifying to what they saw or heard or did or things like that. Now, keep in mind again that we're talking about how somebody who wasn't there, they weren't the victim, they weren't the perpetrator, they didn't witness what happened, how those people, which is most of the world, try to figure out what's actually true. Try to find enough evidence to determine, all right, who's guilty and who's not, who did what, and before they decide what to do about it. Like first they have to prove, like, okay, this person's been accused of a crime. Did they actually do it? So when it comes to testimony, first of all, the question is, does this person who wants to say stuff about it, do they actually know anything? Do they have any firsthand experience of what happened? And it doesn't have to be that they were there and saw the crime happen. It may be, well, I saw the guy in his backyard with a big butcher's knife and he was like watching blood off of it. Okay, that's still testimony that might be relevant. And so that counts as evidence. And because we're just people and we're not all honest, and even when we are being honest, our memories aren't the greatest, our perception isn't always reliable, the idea of testimony is inherently imperfect. Like somebody might have thought they saw something and they were wrong, or they remembered it wrong, or they couldn't remember all the details, so it was incomplete. Or they're just lying, and they're intentionally lying, because you can pay people to be witnesses, to testify. Like if somebody's in trouble, I'll pay you if you'll say that I was with you last week when I was really out murdering people, but I'll pay you to say I was with you. So testimony is a kind of evidence where you have to judge the credibility and the honesty of the one saying stuff and decide whether to believe that. And again, that goes back to the reason for a jury, a bunch of neutral, unattached people who weren't involved in the incident and who are neutral, looking at the evidence and deciding what they think. And that includes listening to people testify and say stuff. And maybe they're saying true stuff and maybe they're saying false stuff. Maybe they even think they're saying true stuff and they're actually saying false stuff because their memories are fallible or, whatever else. So one thing that is built into the system, and you'll see this all the time in like crime dramas, and that is the person comes up to the stand and, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Why do they do that? Because they're trying to create a disincentive to people lying. Because if somebody you don't know says, I'll give you $100 to say I was with you last week because I was actually off murdering somebody. But if you say I was with you, then they might go, oh, well, he couldn't have been over here murdering this person. He was with that person. So I'll give you $100. So the person offered $100 obviously has an incentive to lie. Now, hopefully their conscience gives them an incentive to not help cover up a murder, but let's say they don't really care about that. The concept of testifying under oath basically means I know that I'm in big trouble if I get caught lying, and that's known as perjury. If you're under oath and you knowingly lie, that's perjury, and that's a separate thing that you can be punished for, even if you had nothing to do with the crime or nothing to do with the original case. If you're under oath and you lie about something, but if you just if in this, wandering around talking to people in the street, you say something that isn't true, like, I don't know, I was the team captain of the football team in high school. Like, you don't get arrested if that wasn't true, and you shouldn't. Like, not that you should go around lying, but tackling you and tying you up and, putting you in a cage for making stuff up is a bit much. But when it comes to determining who actually committed a crime and who hurt somebody else, it's important enough to get to the truth that it's basically putting people on notice that if you lie in this context where you're maybe you're lying in the direction of getting someone innocent punished. Like maybe you're thinking, well, I really think he did it. I don't have any evidence, but I really think he did it. I'm going to say that I saw him do it to get him in trouble because I'm pretty sure. If you do that, that's perjury. And by the way, it's perjury even if he really did do it. If you lie to get somebody convicted, it's perjury. If you lie to get somebody found not guilty or acquitted, that's also perjury. So the concept of testifying under oath is to tell the person there will be consequences if we find out that you lied here, because this is really important that you tell the truth. And so that's something that in courts, at least in the US, this may be true in a whole lot of places around the world at this point. There is no testimony in court that isn't testimony under oath. You'll always see it start with swearing in the witness, promise to tell the whole truth. And, they may have different versions of wording that, but it's basically you're not allowed to say anything. You're not allowed to testify at all if you're not under oath and know that if you get caught lying, bad things might happen to you. And incidentally, that's one of the things, this is sort of there's a whole bunch of technical legalese stuff I'm not going to get into because it doesn't really have anything to do with the underlying principles. It just has to do with the weird legalese system that's evolved over time. But a lawyer is not allowed to testify. He's not giving evidence. He's supposed to bring in witnesses to actually testify. But he's not supposed to say, that guy over there, I saw him beat up his neighbor and steal his car. It's like, you're not under oath. You're not a witness. You're not supposed to be providing any of the evidence. Other people have to provide the evidence by way of testimony. And even when there's physical evidence, like here's the bloody knife, it's like, okay, you have a bloody knife. Where did it come from? You need to bring in a witness who's going to say, whether they're a cop or somebody else, I found that bloody knife on this day, and I'm testifying under oath that here's what I saw, here's what I did. I'm describing what happened, here's where the knife came from. I took it right away to the police station or whatever. I took it to somebody I know who knows how to test blood to see what blood type it is, to see if it matches the blood. Whatever you did, even when there's physical evidence, you usually need a witness to testify to what it is, where it came from, why should we believe that's anything, and not plan it on him or anything else. And again, there are ways to be dishonest anyway, but the purpose of these rules is to hopefully make it harder to be dishonest and harder to punish an innocent person. And that includes punishing an innocent person by accident because somebody thought they did it and so they lied to get them in trouble, which has happened a lot. There are a lot of cases where government has prosecuted people and convicted them and stuck them in jail for a very long time, only to find out, oh, now we have evidence, like by DNA or something, that proves they totally didn't do it, which means your case was built on lies of people lying under oath. Now, maybe it's people being mistaken sometimes, but a lot of times it's people lying, and you can get in trouble for perjury. Unfortunately, that doesn't happen very often where cops totally get caught lying under oath. A lot. Testa lying, they refer to it, like cops refer to it as testa lying, and they rarely get in trouble for it, even though technically it's a crime. But notwithstanding the current government version of justice, the underlying concept of testimony under oath is a good one. It's saying, okay, before you tell what you know and tell all these people, whether it's a jury or everybody in the town or something, what happened, do you realize how serious this is? And you realize how serious it is for you to lie. And that, bad things might happen to you if you get caught lying about this, either to let a guilty person go or to get an innocent person in trouble. So, and that has to do with admissibility and stuff. Testimony isn't admissible at all unless the person's under oath. And there's a very simple reason. But there's another thing about witnesses and testimony that I might as well get into now, which is the right to confront your accuser. If, again, example of the person whose car is missing, and he says, I bet my neighbor did it. Can't really prove it, but he's suspicious, says, I think my neighbor does it. This concept, the right to confront your accuser, is the idea that and it's described in a bunch of different ways, the right to have your day in court if you're the accused, meaning you have the right to defend yourself and say, wait a minute, I wasn't even in town that week. What are you talking about? Like, you said your car was missing this morning. I had a flight from some other city and I only landed at noon today and I can prove it. Like, here's the ticket. Like, it's the right of the accused to say stuff and defend himself. Now, in a bit, we're going to get into his right to not have to do that, his right to remain silent. That's going to come up next. But he also has the right not only to present evidence, but to challenge the evidence that the other person is using against him. So the right to confront your accuser is just describing the one who is actually accusing you. Like the neighbor says, he did it. And he's like, wait a minute. Okay, you're accusing me of stealing your car. When do you think I did this? And how, like, was it in your locked garage? How do you think I got in? And where's the car now? Like, it's sort of the right to call into question what the accuser's saying. But a similar right applies not just to the actual person accusing, but to anybody testifying. Because, for example, if the guy with the missing car calls in a neighbor and says, okay, I'm going to have you testify. I'm going to have you say what you saw. And the neighbor says, well, I saw him like walking around your garage late last night or something. And let's say this person's trying to be honest, like the person testifying. But the right to cross-examine witnesses, and you'll see this all the time in court and TV crime shows, the prosecution will be questioning somebody, and then the court will say to the defense, your witness, which means it's your turn to ask him questions, because the prosecution isn't allowed to bring in a witness, say a bunch of stuff, and then say, goodbye, we're leaving. You don't get to ask them anything. There's the right to cross-examine the witness. So the guy might say, wait, okay, you've said what he wanted you to say, that you think you saw me walking around late at night. What time was this? And where was it? And what made you think it was me? Was there enough light to even see me? Well, I don't know. It was dark, but it looked like about your size and shape. Okay. So you saw somebody, you say, that was about my, height and weight, maybe. How sure are you that it was me? And the right to challenge them, and because that's what cross-examination is I want to see if your story actually holds up. And you might find out, like, well, what time exactly? Because maybe he'll say, maybe the witness will say, I saw him like sneaking around your garage at night. And that's all he says. Wow, that seems pretty damning. And that's all the guy with the missing car wanted him to say. And then the other guy comes in and says, well, when last night? It was about 11 o'clock. Oh, well, I came in at midnight on this plane and here's my ticket. And the fact that I was allowed to cross-examine you and find out exactly when you thought you saw it shows that you didn't see me. You saw somebody else that maybe looked like me or was the same size, but here's my proof. But that wouldn't have happened if they didn't have the right to cross-examine and say, well, what exactly did you see? When? Where were you? From what angle was there, and to be able to question that and challenge that is fundamental to due process instead of just hearing one side of the story. Because, we've all heard that, there's two sides to every story. And this is really just the concept of you don't decide somebody's guilt just based on one side of the story, because it's pretty easy to spin things and say certain things and emphasize certain things and maybe lie here and there, and then leave out a whole bunch of other stuff and make the guy seem really guilty. Where if he had the right to say, wait a minute, I challenge that witness. How did you know this? And when did this happen? Or even just like, were you paid anything to say that? Knowing that you're under oath. So it isn't just the right to confront the actual person accusing him. It's the right to confront the witnesses. And it doesn't even have to be like a hostile, nasty thing. Confront just means I get to ask you questions too. Because the witness may be neutral. They may not know what happened. They're just like, well, I saw something and I was told to come in and say what I saw. So I'm going to. But both sides are trying to get them to say things that match the outcome they're trying for. But the right to cross-examine a witness is sort of essential to that. Is like, if you can accuse me of something and bring in people to testify to it, but I'm not allowed to point out problems in their story or reasons why what they testified to either isn't accurate or is totally irrelevant, or, for one reason or another, isn't actually the evidence that it might seem like if you only hear one side of the story. So that's, that's the thing about testimony, being under oath and having the right to cross-examine people. Again, both of those concepts are designed to protect the innocent victims of a crime and the innocent people who are falsely accused of the crime. So we talked about the right of somebody who's been accused of a crime to confront his accuser and cross-examine witnesses against him and see the evidence. There's something called discovery in the U.S. system and in a lot of other systems, I'm sure too, where, and this is something that the TV misrepresents all the time, when you go to trial, the prosecution has to give to the defense being the person who's accused of stuff and his lawyers and stuff, give all the evidence. Like in TV shows all the time, you'll see like they set them up and then they go, haha, this piece of evidence showed that you just lied. That doesn't really happen. They're not allowed to do that because they have to give all the evidence ahead of time, and both sides do their version of discovery of here's what you're going to introduce at trial. You have to tell them ahead of time. And that ties into the last thing we were talking about of confronting the witnesses for the other side, is you need to know like who they are and what they're going to talk about ahead of time. Or even if it's physical evidence, like we have this bloody knife, it's like, all right, well, what is it? And we have to be able to like look at it and see it and be able to say, wait a minute, that's like, you said a knife was missing from my set. That isn't the same kind of knife. And I may never have known that and been able to point it out if not for the concept of discovery, where you have to provide all the evidence ahead of time, including who the witnesses are going to be and what they're going to testify about, so that people can look into it and plan ahead for the trial. Because a trial isn't ever supposed to be, gotcha, even though that's constantly what it is on TV. The actual concept of justice isn't supposed to be a tricky trap. It's supposed to be, here's the evidence laid out that either proves this or it doesn't. And the whole gotcha thing makes for exciting drama, but it's not how it's supposed to actually work. Now, there is the thing of occasionally you can accidentally get, or you can get a defendant to accidentally say something that totally, makes him look guilty because whoops, he accidentally blurted out the wrong thing. And that thing does happen. But when it comes to the actual evidence and planning testimony, there isn't such thing as we're going to sneak you in and you're going to give this testimony and surprise them all. Like there isn't supposed to be that, because both sides are supposed to know what's the evidence. It's not supposed to be a game of tricking. It's supposed to be a game of here's the evidence, and then a jury can look at all of it from both sides and decide what they think about whether guilt was proven. So we talked about the right of the accused to confront his accuser and the witnesses, but at the same time, he has the right to remain silent. And I'm sure you've seen this. This is like the most cliche legalese thing. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney if you cannot afford one, blah, blah, blah. What's known as the Miranda warning in the United States, which is named after a Supreme Court case where the Supreme Court decided you actually have to tell people that they don't have to answer questions and they have the right to remain silent. Because before that, cops could sometimes get away with like, tell us, where were you, and grill somebody. And the person thinks, well, you're the cop, I guess I have to answer. And they didn't legally have to answer, but they may not have known that. And so the Miranda decision, and there's a bunch of other case law about it, was basically saying, no, you actually have to tell them that they don't have to testify against themselves. Now, this is one of those things that for a lot of people may seem counterintuitive. Like, well, if you didn't do it, who cares if you're made to testify? In other words, if they make you say, I didn't do it, what's so bad about that? And if you did do it, like if you murdered 3 people, then why shouldn't you be coerced into admitting it and testifying against yourself? What's the point of that? And so a lot of people, the whole right to remain silent is sort of like, why is there that? Like a lot of times it doesn't seem like that's actually in line with justice. And that can be true. That can be true, where if you bludgeon somebody enough to get him to confess to something he actually did, you might get justice out of it. But again, first and foremost, the purpose of these rules and all this, all the things I'm talking about in this whole video series about what is justice is to protect not just the innocent victim of a crime, but the innocent person accused of a crime. So if you're accused of something, you have a right to say what happened and explain yourself and do all that. But you also have a right to say nothing because the burden of proof isn't on you. They have to prove it. And they can't say, well, he's not saying anything that proves he's guilty either. They're not allowed to do that in court. I mean, they kind of try to do that anyway. Technically, they're not allowed to. But why bother having a right to remain silent? Like, if you didn't do it, say you didn't do it. And if you did do it, then isn't it okay to make them say they did it? Well, here's the problem. And here's something that's hard for people to understand if they haven't been through the coercion and interrogation that a lot of authoritarian powers have done. Used to be churches, now it's governments that will take somebody and force a confession out of them for something they didn't do. And if you can coerce somebody and you can torture them into like, admit that you worship the devil or something, you can look at the Crusades and all sorts of stuff where people, they were accused of heresy or accused of being witches or something. And we're going to torture you. And while you're being tortured, like if you know that saying, okay, I'm a witch will make them stop torturing you, eventually you're going to say, okay, I'm a witch when you aren't. So forced confessions is totally a thing and has been for hundreds of years. And it's why, there's the issue of things that have gone on in Guantanamo Bay and stuff and torture facilities and people being waterboarded to get them to say things. And some people may be tempted to say, well, I mean, if you know some terrorist plot coming up that's going to get 100 innocent people killed, then I don't care if you get tortured to make you admit it. And in a way, I don't either. The problem is the people who don't know that and are actually innocent, if you torture them until they say they're terrorists, they will say they're terrorists too. And this may be a hard thing to grasp. Like, why would somebody admit to something that wasn't true? Well, if you're in extreme pain and on the brink of what you think is dying, like being waterboarded, you're going to say absolutely anything it takes to stop that from happening right then, to put an end to that. And the thing is, the CIA is fully aware of this. And they've actually, they're well aware of the fact that when you torture people, the information you get is not at all reliable. Like if they torture somebody and say, who are you working for? And they go, I don't even know what you're talking about. I'm not working with anybody. That can be totally true. And if they keep torturing you and saying, who are you working for? Eventually the person's just going to make up names or name somebody real that they don't even know anything about. And if they say, are you working with so-and-so? They'll go, yeah. If you'll stop torturing me, I'll say I'm working for that guy. I don't even know who it is or what he did. But because forced confessions work and are completely unreliable, they're supposed to be A, inadmissible as evidence, and B, you're not allowed to force it to begin with. And that's the reason for the right to remain silent. It's not so that guilty people don't have to say what they did. It's so innocent people accused of stuff don't have to justify themselves or say anything or answer any questions. And there's such a cliche example of the cop that pulls somebody over and says, do you know how fast you were driving? And if you say, yeah, I was going 10 over the limit, well, you just confessed, way to go. Now you got a speeding ticket. And he said it. Like maybe he had other evidence anyway. Maybe he didn't. But when they ask you, so where are you going? And have you had anything to drink? And blah, 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 blah. They're looking for a reason to fine you or arrest you. And you might accidentally give them that reason, even if you didn't try to do anything wrong and didn't think you had done anything wrong. Like, oh, maybe there's a half there's an open, half-drunk beer bottle in the back of your car that your stupid friend left there with all his stuff when you dropped him off a half hour ago and you didn't know he was there. And you're like, oh, here's what I was doing. Here's where I went. Sure, you can search my car. And then you accidentally get arrested by testifying against yourself when you didn't actually do anything wrong. And it was because, like, the Fifth Amendment, the right to remain silent, I plead the Fifth Amendment, was written and included in there as a result of, many, many, many years and centuries of people realizing, yeah, you can force people into confessing anything. And we can't have that. That doesn't match justice. If you're allowed to torture and intimidate and coerce somebody into saying stuff, then you can get them to say stuff that isn't true to their own detriment, or accidentally say stuff that is true that makes them look guilty when they're not. And so the right to remain silent is one of those things that may not initially seem that obvious to people. Like, why don't you just say you didn't do it? And that goes along with the thing of like, well, if you have nothing to hide, why won't you let the cops search your car or your house or anything else? And it ignores the underlying principle of why they're not allowed to do that. And sometimes they do it anyway. But why they're not supposed to do that. And there's a very big, serious, fundamental reason that justice demands that you can't make people testify against themselves, and you can't rummage through their stuff, and you can't detain them without a good reason, like we were talking about in prior points. But the right to not testify against yourself is once again a thing that the courts and the cops try to get around, and they try to do tricks with. And the most glaring example, which is so bad that it's actually outlawed in a bunch of countries, is known as plea bargaining. And it is absolutely being forced to testify against yourself. Doesn't matter that the Fifth Amendment says it's not supposed to happen. Not only does it happen, the vast majority of criminal cases in the United States are a direct result of someone being forced to testify against himself. And the way it works is prosecution comes to the person and says, if you make us take this to trial, we're going to try to get you imprisoned for 10 years, like whatever it actually is. But if you plea bargain and just admit that you did it without us having to prove anything, if you testify against yourself, say you were guilty, then we'll only put you in prison for 3 years instead of 10. And so a lot of people, over 90% of criminal cases, I believe, in this country are settled by plea bargain, which means the government never proved anything. There was never a jury trial. They never had to introduce the evidence. They never had to go through the process of making sure the evidence is reliable. They never had to let their witnesses be cross-examined. They never had to let the person confront his accuser because they intimidated the person into just giving up and saying, I did it. You can send me in for 3 years, whether I did it or not, because I'm scared that you'll put me in for 10 if I don't confess. That's a forced confession. It is obviously a forced confession, and it's illegal in a lot of countries, which is why they don't do plea bargains in a lot of countries, because it's obviously a forced confession, and it's how most criminal cases in the United States are settled, by the person being coerced into pleading guilty when theoretically he has the right to remain silent. It's like saying you have the right to remain silent, but I'm going to break your knees if you don't tell me what I want to hear. So again, that's a shining example of the difference between the theory of the right to remain silent, which is a good idea. It came from people actually thinking out. Justice requires that we not be allowed to force people to confess or testify against themselves, and then put into practice how it is today. The government constantly violates that all over the place, and they don't care. They will intimidate and bribe and threaten and rob and coerce people into doing a plea bargain and admitting they're guilty, whether they were or not. Because if somebody, if you're in some poor neighborhood and you have no money, you can't afford a lawyer, you don't know how any of this works, you don't understand any of the principles and terms I've been talking about here, and the cops and the courts and these fancy people in their fancy suits are saying, yeah, we have all these cases, as cut and dried case, we're throwing you in the slammer for 20 years unless you plea bargain, and then we'll only give you 5. It's so, if a person totally didn't do it, but they got drugs planted on them, Why wouldn't the average poor person who has no money, doesn't know what to do, doesn't know how the game works, they know that the government has unlimited resources, and they think, yep, they can probably just frame me for this and put me in for 20 years if I go to trial, and the stress and how am I going to get a lawyer? I can't represent myself. I don't know how any of this works. And it'll drag off for ages, and then they'll put me in a cage for 20 years, and I may be in a cage between now and then too, if I can't post bail. And so a lot of people who aren't guilty just plead guilty for a relatively minor punishment to something they didn't do. They're being forced to testify against themselves. That's how most criminal cases in the U.S. are settled. It's illegal under the Fifth Amendment. It's immoral under the principles I'm talking about, and the government doesn't care. That's still how most criminal cases go. And it's a blatant violation of the concept of having the right to remain silent and not being forced to testify against yourself. So it's a very good principle. It's just absolutely ignored in the United States. They give lip service to it. When the cop arrests you, he'll tell you you have the right to remain silent, and then later he'll coerce you into confessing under the threat of, we'll punish you really, really bad if you don't confess. And so it's, in this country, it's become a joke, like a number of these principles. That doesn't mean the underlying principle was a bad idea. It means we should actually do what the underlying principle says, including without government, even if we're just people trying to figure out what's going on. Like normal people, if this guy is accused of stealing that guy's car, normal people should realize you don't get to waterboard him until he admits he stole the car. That's not okay, because if he didn't, that's really, really bad. If he didn't take the car, that's really, really bad. Even if he did take the car, it's pretty bad. But if he didn't, and you torture him until he says he did, just to stop the torture, that's horrible. That's worse than stealing a car. So we're not going to do that. We're going to have that principle and that concept so that we can try to obtain justice as often as we possibly can. So many of these concepts, there's sort of a gray area, and people have to decide, like proof beyond a reasonable doubt. Well, who's deciding what counts as a reasonable doubt? Well, just human beings, and we're not perfect. And so everywhere there's sort of going to be a gray area where people have to just decide, like, all right, how reliable is that witness, and what counts as reasonable doubt, and things like that. So one that's a huge gray area is the concept of cruel and unusual punishment. And I mentioned before, if some kid gets caught stealing a candy bar, it's not okay to like drag him off to the guillotine and behead him for a Snickers. The cruel and unusual punishment is like, we want, after we've proven somebody did something, we don't want the punishment, the retaliation, the deterrent, whatever you want to call it, or whatever you want to think of it as, we don't want it to be way out of proportion. Well, that's sort of just automatically true among decent people. But to say there shall be no cruel and unusual punishment, well, as judged by who? It's a judgment call. And people are going to decide. Like once upon a time, and probably still in places of the world today, if you got caught stealing, they would chop your hand off. Nowadays, in the US, we view that as pretty barbaric and extreme just for like petty theft. And, I think it's pretty dang extreme and barbaric just for petty theft. So there's the culture you grew up in and the people around you and sort of what they expect and what they think of different crimes. And, you can look at other cultures and think, wow, their view of what's acceptable and the things you might get stoned to death for is just bonkers. But either way, it's people deciding, well, what counts as cruel and unusual punishment? What's a disproportionate response to someone stealing a Snickers or stealing a car or killing somebody? And so there's constantly an argument over, well, what counts as cruel and unusual punishment? And because there's no way to really measure that objectively, it's going to come down to opinion and sort of cultural norms and what people think is acceptable. And so to say there's not allowed to be cruel and unusual punishment, I mean, it's a nice idea, but it kind of doesn't mean anything because who's deciding what counts as cruel and unusual? Like the only thing it protects people from is if government is trying to inflict some punishment that all the normal people say, that's way overboard. What are you doing? And that does happen. But if you're talking about a situation where it's just people deciding what to do, by definition, they're going to decide something that they think isn't overly cruel and unusual and whatever else. Again, the unusual part is sort of weird. Like, well, we usually punish people by doing this, but we're going to do something weird instead. Like, well, maybe it's weird and nicer. So it's like, it still comes down to a judgment call. Like, all right, you got caught stealing a Snickers bar, and, maybe before we'd like put you in a cage overnight or something to make you think about what you've done. But now we're going to make you like pick up trash in the park. And if you say, well, that's unusual, you don't usually do that to people. Okay, still might prefer that to being in a cage. So the fact that something's unusual doesn't mean it's worse. So it's, that sort of thing always comes down to a judgment call. And in the end, constitutionally, how are you supposed to enforce that when people can just differ on what they decide counts as cruel? And it sort of just comes down to popular opinion. If most people go, oh, that's way overboard, then it's harder for government to get away with it. Doesn't mean they won't try. Doesn't even mean they won't get away with it. But the concept is a good one. It's just always a judgment call. So